Okay. Counsel, does anyone want to put anything on the record right now?
Yes, Your Honor, there are a couple of issues we would like to raise.
Okay.
Your Honor, in the anticipation that the state is going to rest tomorrow, we have noticed that the defense is going to call some witnesses. The defense has provided a somewhat lengthy list of witnesses that I believe would be characterized as 404A1 witnesses or character witnesses. I got note of at least probably 12 witnesses. I just wanted to know, this is essentially a prospective motion to prohibit needless cumulative evidence of 404A character evidence. So far, we've heard from Johnson, who's elicited a character opinion, Fleslin, who's issued a character opinion supportive of the officer, Sergeant Peterson, who's also been offered a character opinion. I, based on the discovery, anticipate that Colleen Fricke will share one, and then also former Chief Gannon. That would be 5 to date. That would be notwithstanding, I think, the 10 pending based on their witness order. The court has heard the needlessly cumulative objection raised by the defense, I guess repeatedly since the trial began, and the court has sustained some of those objections. Here the shoe is on the other foot. At this time, the state is objecting to the defendant's apparent intention to present additional character evidence beyond that of Fricke and Gannon's. At some point, Your Honor, and we think it would be after Gannon's testimony, that would constitute the needless presentation of cumulative evidence. We're bringing this up prospectively now because, given the abundance of witnesses, I think that if the court properly guides the defense, they can have their choice as to who among them they would want to call if they chose to go a different direction. You have not seen and will not see the state attempt to contradict these opinions shared. Repeated testimony along the same lines illuminates nothing further, and it's an improper effort to bring a chorus on these issues where I think soloists have already done the job. At some point, such testimony has no probative value. It's duplicative, and the state's position obviously is, after Gannon testifies, 5 is enough. When we have addressed these issues of cumulative evidence so far, the state has referenced to State v. Amos. That would be at 347 Northwest 2nd, 498. That's a Minnesota Supreme Court case of 1984. Essentially, in that case, a party decided they wanted to parade a bunch of witnesses into court to testify that a particular location was notorious for drug dealing and gambling. The court allowed 3 witnesses to provide such testimony, but after that did exclude further testimony as being needlessly cumulative. Here we have the same point. We have heard from these witnesses. The state is not even objecting to the defense calling Fricke and Gannon for those purposes, but at that point it seems like the point has been made and that the court is certainly within its discretion to exclude further character evidence. There isn't perhaps a 404A1 case directly on point, Your Honor, but there is a case within the Spriegel realm. I referenced State v. Washington. That's 693 Northwest 2nd, 195 at page 203. In that case, the Supreme Court noted that it was proper to limit Spriegel evidence at a certain point to reduce the risk that juries will become fixed on it and will blur the lines between evaluating the elements of the offenses charged and simply the evidence of the defendant's character. I think that it's right for the court to consider that, and I do believe that it's timely, although a bit prospective, for the court, for the state to raise that motion at this time. That's the state's first motion with regard to this. I believe the state has 2 other 404A1 motions. We could hear this first, or I could give it to you all now. Which would you prefer?
Okay, I would like the defense to respond at the podium. Mr. Ng, how many character witnesses are you intending on calling?
Well, we're not going to call 12. We had 5 scheduled for tomorrow. Sam Smith, Lisa Thies, Ann Curtis, Frank Roth, and Tom Hall. We were going to evaluate when they got in how many we were going to use. I'm somewhat sensitive to their claim, although I'm somewhat insensitive to the idea that the state has been efficient in their presentation. I find their presentation to be entirely redundant, and so the claim here that we can't spend 15 minutes on some testimony doesn't resonate with the defense.
Well, it's good to hear that you're not going to be calling 12.
No, of course
Okay.
not. And, you know, the police officers were fact witnesses. They happen to
I'm
know
talking pure character witnesses.
For pure character witnesses,
Okay.
we have 5. I may not call all 5. Those are the pure ones. That's the only reason they're here.
Okay. Are they all 5 of them going to say the same thing?
Well, I'm constrained by your ruling as to peacefulness and law-abidingness. Yes, you know, I know her. We met her. I've known her since childhood. I've known her for 5 years, 10 years. You know, that sort of
Okay,
thing.
pick 3.
Pick 3. We will do.
All right. Okay, anything else? Oh, I think you had another
Yes,
motion. Okay.
I would note, Your Honor, depending on which 3 the defense calls, we may have no discovery from any summaries of any statements made, so I wouldn't make any demands of any statements made by those witnesses, respectfully. At this time, this, I guess, motion pertains strictly to Officer Fricky and Tim Gannon, who are apparently prepared to provide character opinions. So I don't know whether they are included in this group of 3 that
They
the
are
court
not
talked
included.
about. Because Tim Gannon is not a fact witness, Your Honor. But at this time, the state moves to limit the opinions of Officer Fricky and Tim Gannon to those specifically permitted by the court. And I know that we just went over, Mr. Eng went over what he believes the court's ruling was with regard to what pertinent traits are relevant in this case. That would be law-abidingness and peacefulness. In the defense interview with Officer Fricky, though, additional opinions were laid out that I think are beyond the scope of the court's ruling, and I'll just list things such as patient with suspects, unfailingly polite, treated everyone with respect, devoted to victims of abuse, had a reputation for honesty. For admissible 404 opinions, I believe Officer Fricky has opined that there's a willingness to follow the law and something about being a good police officer. The state is asking the court to limit her opinion to those only which are admissible. The others seem obviously outside the scope of the court's prior ruling.
Well, Officer Fricky works for Brooklyn Park now and was an officer for Brooklyn Center for almost 15 years and worked with Officer Potter. Officer Potter was her mentor and partner in many shifts, and the witness summary discussed what it was like to work with her. What was she like as a police officer? And so I certainly will respect your ruling on law-abidingness and peacefulness. I'm not going beyond that, but she can describe what it was like to work with her. In fact, she was asked to stay with her after the incident because she had worked with her, and she was specifically asked to stay with her for the duration. So that's the context for that.
Okay. Could I get the witness summary for
I
her?
think they gave you the summary.
All right. I don't know if I still have it. Could I get another copy?
Sure, Your Honor, we can probably get that back to you.
Okay. All right.
I do appreciate Mr. Eng's comments, and I guess I wasn't expecting bad faith, but I certainly thought it was worth making a record of this. General background information that would form the foundation for her to elicit that opinion is certainly sufficient. Where I think that there can become issues is when someone preparing to elicit a 404A1 opinion goes extremely specific in describing the background, which essentially accomplishes the prohibited goal of talking about specific instances. So I'm going to take Mr. Ng at his word, and we'll just act accordingly. Lastly, Your Honor, obviously Ms. Potter's under no obligation to testify, but there were some of these individuals who opined with regard to truthfulness. Truthfulness is obviously not a 404 opinion. That would only come in pertinence after she testifies, after her credibility is attacked, and it would come in under 608A. That's all with regard to 404 issues, I believe. Pardon me.
There was one other issue that was not a 404 issue with respect to character witnesses that we'd like to address, Your Honor.
Okay, please go to the podium. First of all, let me just say that specific instances of good conduct is not going to be admissible under 404, okay? Character traits only.
I appreciate that, Your Honor. I think just to dovetail off that, obviously, Commander Flesland was asked some questions about whether Ms. Potter was a good cop, and he said she was a good cop and a good person. We objected. That was on the record at sidebar, but whether someone is a good person is also improper character evidence, so we would continue to object to that.
Yes.
Stemming from that as well, when it came to Commander Flesland's testimony, raises another issue. Obviously, the state had briefed a motion with respect to potential bias, union membership. We argued that motion to the court. That was yesterday, I believe. After we argued that motion to the court, however, was when Commander Flesland was called. Commander Flesland was called, and then on cross-examination, defense counsel elicited testimony directly from him about the scope of union work that Ms. Potter did, her role as a union steward. I had pulled some of the testimony, but the questions were essentially about negotiating a contract, but then there was follow-up questioning about additional duties beyond negotiating contracts. Mr. Gray asked what else would that be. That included representing officers and detectives in the bargaining unit, helping negotiate if they've been wronged, and potentially go down the grievance route for something like that. The union stewards help them navigate that process. It's our position, given the testimony elicited by defense counsel in this case, that they have opened the door clearly to any potential cross-examination on our behalf of their witnesses when it comes to bias, union membership, and union affiliation.
Would the defense like to respond?
Well, Your Honor, I'm not quite certain being a member of a union shows bias. I didn't expect the answer that I got when I asked Commodore the question about the union. I believe that our client, just negotiated contracts. She didn't do much else. She will testify to that. I have a hard time believing that in this day and age, the state of Minnesota is accusing a union member of bias because she belongs to a union. It's hard to believe. But if they want to attack our client, because she's a union member, it seems way out there. It doesn't seem relevant at all. I mean, how many on the jury, how many people in our nation are union members? I think the public defenders are, county attorneys are. All kinds of people are union members. What does that mean? I mean, so you're the union steward. Would that mean you're going to take the stand and lie? I don't think so. And I think that's why it's improper to impeach somebody by, oh, you're a member of the union. Oh, she's the head of the union. That's not proper impeachment nowadays. Thank you.
Okay, I think the state's point was that with respect to defense witnesses, they want to be able to cross-examine and show that defense witnesses may be biased because of Officer Potter's former position as union president, I think it was.
That's correct, Your Honor. The state is in no way criticizing anybody for being a member or not being a member of a union. The issue goes directly to the heart of whether or not bias exists, and that relationship between each of these witnesses, each of these officers who may have used or relied upon the defendant to help them through a grievance process, who looked up to her as president of the union, who went to her for advice, who, she may have shepherded them through this process of addressing grievances, and she was essentially their advocate. That goes to bias bias of each of the witnesses who testifies, not only to her character, but also whatever testimony is elicited through the defense direct. So not only is it bias with respect to anything that may come out if the defendant should choose to testify, but each witness who testifies about a relationship with Ms. Potter, there's a connection there that is deep-rooted, deep-seated. There is an established relationship, and clearly it's probative of bias for us to be able to ask questions about that relationship.
Well, it would only be probative of bias if Officer Potter actually represented any of these witnesses and had a close relationship with them because of her former position.
And Your Honor, just getting brief highlights of the testimony from Commander Flesland. His testimony was that they're there to represent the officers and detectives or whoever is in that bargaining unit. They can help that officer negotiate if they've been wronged and potentially go down the grievance route for something like that. The union stewards can help them navigate that process. So that testimony was elicited by the defense. That shows that relationship and the assistance that Ms. Potter would have given them.
Okay. Anything further on that?
No. But one of the three character witnesses may be a police officer, rather than a lay witness. So I've got it down to three.
Okay. All right.
Judge, she wasn't the union member for most of these folks that are going to be testifying. She wasn't the union advocate in the first place.
Okay, you can bring that out on cross.
Yes.
All right.
I mean, I don't. Okay.
Okay. Mr. Frank or Mr. Larson? Okay.
You've already argued something in chambers, Your Honor. I was just going to ask whether the court has made a ruling on Exhibit 1002.
What's 1002?
Can you refresh the court's recollection?
Yeah, please.
I believe it was yesterday, defense counsel shared with us a short video from a time frame
yes.
when Officer Potter and Officer Fricky were at the Brooklyn Center Police Department. Need I say more?
Yeah, I remember. I did review that video, and I'm not going to allow it. She can testify as to what her interaction with Officer Potter was, and I'm doing that because it really isn't relevant to the issues in this case. So, but I'm not going to restrict her from testifying about it. Okay. All right. Mr. Frank?
Your Honor, I think this is the last thing we have, and we just thought we should raise this with the court now so it doesn't come up tomorrow as we're trying to move through the testimony. And, Your Honor, we, I think, have provided the expert reports to the court for your review. I believe I heard Mr. Eng in opening say that Mr. Imes will testify, their use of force expert, about deadly force. And if I misheard him, I apologize, but because I'm not certain about it, I wanted to raise it. Now, there is nothing in Mr. Imes' report about the use of deadly force, and so we would object. The disclosures were required months ago. Nothing in that report about the use of deadly force, as our witness testified about. So we believe that that is not proper testimony from him. We just wanted to raise that with the court now so the court's aware of it.
Okay, Mr. Eng?
It's permissible for the expert witness to review evidence as it comes into the case. I've asked him to review the testimony of, in particular, Sergeant Johnson and Officer Lucky. I've also asked him to review the testimony of Mr. Stoughton today, particularly as to the reasonableness of the force and his analysis of the dangers inherent in the setting, and to agree or disagree with Mr. Stoughton. So this is new evidence that was not available. The testimony certainly wasn't available. I've asked him to review that for the purposes of either agreeing or disagreeing, and that's what an expert does. So that's what I'm going to ask him to do.
Okay. Why wasn't that his opinions disclosed earlier?
Well, the initial opinion was that the taser was appropriate to be used, and then as the evidence developed, we've asked him to keep an open mind about it, and our assumption is that there would be new evidence at the trial because, first of all, we don't know exactly what they're going to say. And the Johnson testimony was extremely significant, and he didn't have that. And, one of the cross-examinations of Stoughton was he didn't have the Johnson testimony in his original report either. So the newness of the evidence is what we're going to ask him to look at.
Okay.
But of course, Your Honor, is this microphone going to be okay, or do you want me to?
I think the court reporter can hear. Yeah.
We have absolutely nothing from Mr. Irons about the use of deadly force. So to say this is new evidence means he's creating a new opinion that wasn't disclosed as it was required to be. The Irons report is, I'm sorry, I don't have it right here in front of me, 4 or 5 pages long. It's very scant on its support for its opinion anyway, but now to add a completely separate opinion about the use of deadly force is just, we just had no notice about it as the court ordered. So we maintain our objection to any testimony about that.
Well, I'm duty bound to talk to my expert. I plan to do that in about a half hour if I can get out of here. And he's downtown right now. And I will disclose the nature of the conversation that I have with him immediately. But I'm a duty bound to ask him what his analysis is of the testimony that he's seen. So, that's my obligation as a lawyer for Officer Potter to see what he says now, particularly about the Stoughton testimony and the analysis of it. He's certainly free to disagree with another expert's testimony. And they know that.
Okay.
It's a discovery violation, Your Honor.
Let me think about that one, okay? And I'll let you know immediately. In the meantime, you'll make an immediate disclosure as to his additional opinions on deadly force. Okay, so I'll take that under advisement. And anything else before we...
Well, if I could go on for a private matter.
Okay. Okay, is there anything else, counsel? Okay, counsel, have a good night, okay? And drive safely tomorrow morning. I think it's going to be really icy.